Retaliation laws prohibit employers from taking an adverse employment action against an employee who has engaged in a protected activity. This video is going to look at just some of the activities that would be considered to be protected under the law. This is not meant to be construed as legal advice. If you need to speak to an attorney about a cause of action for retaliation or some other employment law claim, please contact an attorney in your jurisdiction. If you're in California and you think you have a cause of action for retaliation or some other employment law claim, feel free to contact Termeci Employment Law Group for a free consultation. Retaliation laws make it illegal or unlawful to fire, demote, or reprimand an employee in any way because he or she engaged in an activity that was protected by law. Normally, people tend to think of retaliation in this way. Your boss is harming you because he thinks you harmed him, but that is not retaliation under the law. For retaliation to be unlawful, your boss or coworker or supervisor must be harming you because you did something that was protected by law. Now, here are just a few short examples of things that are protected activities under the retaliation laws in California. Number one, if you refuse to violate a law, any law, not just an employment law. If you complain about an unsafe work environment, that would be a protected activity. Number three, if you oppose some type of unlawful discrimination or harassment against you or another coworker, you may have a cause of action for retaliation if you suffer some type of adverse employment action as a result of that complaint. The next is complaining about not getting paid overtime or requesting a reasonable accommodation if you took protected leave of absence or you testified in federal court. Last but not least, if you complained to the labor board. All of these activities that I listed would be considered protected activities under the law. So if you did any one or a couple of these activities, and as a result of doing these things, you were fired, demoted, or reprimanded, you may have a cause of action for retaliation. If you are suffering from retaliation in the workplace and you want it to stop, one thing that may be helpful is to compose a polite and respectful complaint that you can send to your supervisor or human resources manager. This is just putting the company on notice that some type of activity that you've been engaging in is protected by law, and that if you suffer some type of adverse employment action, it would be against the law. Sometimes it's better to consult with an attorney before you issue that complaint, but the internet is replete with examples and ideas of how you can go about doing that. You do not have to be fired from your job to seek remedy for the cause of action of retaliation. As long as you suffered some adverse employment action as a result of any one of those activities that I listed, and that list is not complete, it's just a short list of some things that fall under the protected activity category. Again, if you're in California and you think you may have a cause of action for retaliation, feel free to reach out to Termeci Employment Law Group for a free consultation. Thank you for watching this video. We hope that it was helpful. Be sure to visit us on the web at termeciemploymentlawgroup.com.